Good morning, Mr. Godfrey. Before we call the case, are you mediating with attorneys Nim and Zagorski sometime today on this?
Well, yes, I was to start at 1 o'clock if there has been some discussions going on, so I do not know as of 5 o'clock they were still talking. So I do not know if there's been a resolution, but I'm going to be mediating with them if there is not this afternoon on the school issue.
Okay. I have an appointment outside the office at 4 o'clock, so I'll be here till 3:45, 10 to 4.
Okay.
So obviously I'd like to be here to capture any resolution because this guy.
I would suspect it should be done within an hour and a half, but that's just my take on it.
I suspect they simply want your recommendation, your thoughts to give their client some direction.
And I've already I got 2 pages of my spiel, which both of the attorneys I have told. So that hopefully is going to help them.
All right, thank you, Mr. Godfrey. I appreciate your assistance. Okay.
Calling the matter of Gillian versus Teresa Gillian.
For the record, this matter is before the court for a pretrial conference, the same being conducted via Zoom. President Attorney William Godfrey, representing the plaintiff Seamus Gilliland, and Mr. Gilliland is also present. Good morning, Mr. Gilliland.
Good morning, Judge.
Judge, just a little update. The publication has occurred. I still have to wait till the end, about approximately October 1st, to file the default, and I will do that. I can indicate to the court, my client just informed me that the mother makes a call about once every 3 weeks to speak to the child, and that just started. Unfortunately, she continues to get what my client surmises as being picked up off the streets by police officers for some erratic behavior. She is taken to hospitals for mental health evaluations. After the minimum stay, she is released, and then based on medical records on billing, it appears she then goes into a rehab for a few days and then leaves without completion. But by the time he can track that down, she's already gone. She's aware of the divorce proceedings. I don't know what else to add, Judge.
To the best of your client's knowledge, she's currently situated or living somewhere in the state of California. Is that correct?
Correct, Judge.
All right, and there's still an outstanding bench warrant for her here in Monroe County. Is that correct?
That is correct, Judge. Mr. Osment withdrew from representing her in the criminal case, so that's just floating out there. Mr. Osment is obviously the defense attorney on that case, had worked out a deal. She failed to appear for sentencing, and that's still outstanding.
All right, thank you for the update, Mr. Godfrey. The record should reflect that Miss Gilliland did not appear. Of course, we have no known address for her this morning. And Mr. Gilliland, you do not have a phone number for her?
No, Your Honor.
Okay, to text her and have her appear via Zoom, but in any event, it does appear that the 28 days from the date of publication will expire September 22nd. So let's schedule perhaps a continued pretrial conference sometime in October, Mr. Godfrey. The court will in fact, under the circumstances, waive the statutory 6-month waiting period. So the court will mail out notice of a continued pretrial conference or actually a final pretrial conference. And you can, at the same date and time, notice for entry your proposed consent judgment. If Mr. Gilliland has any information, he can perhaps text it to her. Hopefully she will appear at the time of the entry of the judgment.
Judge, I can do November 1st or October the 11th. Those are the 2 Fridays I do not have any mediations.
Okay. Oh my God.
I have October 11th if you want at 1:30.
We can do October 11th at 1:30. Nothing in the morning, huh? So nothing in the morning. If you want to do the morning, we can go into November. So I want to know what Mr. Gilliland's schedule is.
I prefer
The earlier date, Judge, we can do October 11th at 1:30.
Okay, court will mail out notice.
And then I'll get
Right.
the default processed and then propose an entry of a proposed default judgment of divorce.
Great. Thank you, Mr. Godfrey. Mr. Gilliland, that will conclude this
Thank you,
hearing, and have a good rest of the day. You can zoom out.
Thank you, Judge.
Welcome.
White versus Richard-Carlson.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. Are you Kayla White?
Yes, I am.
Right. Good morning, Ms. White. And sir, you are Richard-Carlson?
Yes, Your Honor.
All right. Short-term marriage. We've been separated since March of this year. And Ms. White, the court mailed to you a form judgment of divorce. Did you receive that?
Yes, Your
No,
Honor.
I did. Okay.
Ms. White, you're the plaintiff. The court mailed you a notice, a form judgment of divorce. Did you receive that?
Technically, no, I did not receive that, but it had gone to my old address.
Okay, well, you have an obligation to keep the court informed of an address. You filed this, you gave the court an address of 3. What is your new address?
6.
All right, so, obviously, Ms. White, when you do move, you should always let the postal service know you have a new forwarding address and you get your mail.
Yes, sir.
So obviously, Mr. Carlson reached out to you and told you we had a court appearance this morning. If you had not appeared, the court would have dismissed this action. Ms. Barr, you've had a chance to talk with the two parties this morning. Is there anything at issue?
There is no issues, Your Honor. They have resolved all issues.
Okay, is that correct? Ms. White?
Yes, sir.
Mr. Carlson, is that correct?
Yes, Your Honor.
All right, so the court's going to take some brief testimony this morning to address that. And Ms. White, I don't know if you want to come down to the courthouse and get the form judgment.
Yes, I
know
will.
it obviously, it was not returned as being undeliverable, so perhaps Mr. Carlson has that at the home.
He
Mr. Carlson,
does.
is there an envelope there at your house addressed to Ms. White?
I don't believe so, Your Honor. I haven't received anything unless it was very recent.
Well, back on August 14th, the court mailed each of you notice at the same address in Rawson Street. And all would have been was this notice to appear for today via Zoom, but in Ms. White's envelope would be a form judgment of divorce, 2 pages. It's a form judgment. You have to check the boxes and both sign it. So you have no mail there for Ms. White, is that correct?
I very well, Your Honor, I think I received it. Yeah, I do have it.
Okay, why don't you grab it and then let's go through that together. Can the two of you get together and meet today so you can fill that out? Both of you need to fill it out. Both of you need to sign it and date it and get it back to the court. You'll not be divorced until the court signs written judgment.
Yes,
Okay,
we
Your
can
Honor.
do that.
So if you don't have it there, Mr. Carlson, someone's got to come down to the courthouse and get another form judgment.
Understood.
Can you both meet and come down to the courthouse this afternoon and then we can give you a judgment? You can fill it out in the hallway and the court can sign it and be done with it?
Yes.
Yes, Your Honor.
Okay, what time can you be down to the Monroe County Courthouse? My courtroom's on the 4th floor. Judge Bronk, 4th floor.
I can be done. I can head down there after the meeting.
Okay,
Same.
well, what, two of you agree upon a time you're gonna meet down here?
Does 10:30 sound okay?
Yes.
All right, so 10:30, come up to the 4th floor. We'll have a form judgment for both of you to fill out and sign, and we can get your divorce this afternoon. All right,
Okay.
can you, so the court will look forward to seeing you, and we'll put your new address in there, Ms. White of Michigan. Right, thank you for your assistance, Ms. Brower. Ms. White, Ms. Carlson, can you both raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Yes, Your Honor.
Thank you. We'll start with you, Ms. White. Ms. White, can you, again, please state your name for the record and your current address?
Kayla Chantel White. Current address
That's
is
lot 8, correct?
Yes, sir.
Okay, Ms. White, is it true that you filed the complaint for divorce with this court on about June 3rd, 2024?
Yes, sir.
Is it further true that on the date you filed the complaint that you'd been a resident of the County of Monroe at least 10 days, the state of Michigan at least 6 months?
Yes, sir.
Is it further true that you married Richard Carlson on October 22nd, 2022, and you separated in March of 2024?
Yes, sir.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance that the marriage can be preserved?
Yes.
Were there any children born or adopted during your marriage who are still minors?
No.
Are you currently pregnant?
No.
Do you have any questions for the court?
No, sir.
All right, to Mr. Carlson, please state your name and current address.
Richard Carlson.
Mr. Carlson, did you hear the testimony of your wife, Kayla, this morning?
Yes, Your Honor.
Was her testimony true and accurate to the best of your knowledge?
Yes, Your Honor.
Do you have any questions for the court?
No, Your Honor.
Okay, so you do not own real estate, correct? Are there
No, Your
any
Honor.
joint debts? Credit card debts in both names?
No.
Ms. White, there's no joint debts?
No, sir.
So each of you will keep your own personal property.
Yes, sir.
You're going to divide that, so each will keep the personal property current in your possession, correct?
Correct.
Is that correct, Ms. White?
Correct.
Okay, that'll make it easy. And each will keep their own automobile. Okay, so the judgment, you'll find it's very self-explanatory. Just got to check the boxes. Spousal support is not awarded, it's forever barred. There's no real estate to be divided, no pensions to be divided, no joint debts. Each keep their own automobile. And Ms. White, obviously, you didn't take Mr. Carlson's last name, so you don't need to change your last name. You've kept the name White.
Yes.
All right, so we'll see both of them in about an hour, about 10:30 then.
Yes, sir.
Yes, Your
All
Honor.
right. We close at noon, between noon and 1:30. So yes, if you come down here before noon, the sooner the better, and we can finalize this today.
Okay.
Understood.
Based upon the testimony that's been presented this morning, as well as the claim filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce from the bonds of matrimony. All right, that will conclude this matter. We'll see you both in sometime later this morning. Then, before the
All
court
right,
for
thank you,
pretrial
sir.
conference, the same as being
Sounds good.
conducted via Zoom. President is Attorney Alex Goldman, representing the plaintiff Sarah James. Ms. James is present, as is the defense Stephen James. Good morning, everyone.
Good morning.
Your Honor.
It's 12-year marriage with the parties only lived together as husband and wife for 3 years. Mr. Goldman, is there anything at issue that needs to be addressed in mediation?
Yes, and I'm not sure the parties will be totally far apart, but I think mediation will be helpful. So custody, parenting time, child support, division of marital property.
Okay, there is no pending DC or
There's
DS
an
case.
there is an active DS case.
Okay, as it mentioned in the your summons,
That is a great question, Your Honor.
it should be. I mean,
Right. I don't know that I'm double checking it right now.
Mr. Goldman, for the future, it should be. So the court has information that when the party's been separated for.
Yeah, I did mention it, Your Honor, on the summons.
Okay, I guess I don't see that in the summons.
Let
It says there
me.
are no other pending or resolved civil action arising out of the same transaction or occurrence as alleged in the complaint.
No, but I said there above that in the domestic relations cases. It says there is one or more pending cases. I don't know that I filed the confidential case inventory
All
identified.
right, I see that, but it'd be nice to actually reference the case number for the benefit of everyone.
Certainly, Your Honor. I'll make sure to do that going forward.
All right. So the issues are custody of parenting time. Obviously, of course, going to look strongly at what the parties have practiced for the last 10 years that they've been separated.
Yes, and I'm sorry to interrupt, Your Honor, but I did file a confidential case inventory that identified that DS case. So I believe my initial filings were all correct.
Okay, maybe the friend of the court sees that. Okay. Is there any real estate that needs to be divided?
Yes.
Okay. Personal properties division, even though they've been separated for all these years, still personal property that at issue?
Potentially.
All right. The parties appear to be young, so I assume it's not any spousal support case.
We are not requesting spousal support.
All right. Is there a significant unsecured debt, joint debt?
I don't believe so.
Mr. James, is there any joint credit card debt that needs to be divided?
No joint debt, Your Honor.
Okay. I guess arguably pension benefits for a short period of time. Good morning, Ms. Patrick.
Morning, Your Honor.
The court
I
does
do have
a
that
mediation
number.
list.
I do have the DS number if you would like it, Your Honor, but yes, we have scheduled this for mediation.
Okay.
I have it scheduled for October 17th at 1:30.
Okay, I will not be available late in the afternoon. Ms. Patrick, is there anything in the morning? I'm not gonna have much available in the afternoons in October and November, but so.
Your Honor,
if
I
there's
do have
resolution, someone else
8:30.
got to handle it. I'd like to be here if possible.
Okay, I do have an 8:30 that morning, Your Honor, if the
Okay.
court would like me to move it to the 8:30.
I would prefer that. Does that work with your schedule, Mr. Goldman? The morning of October 17th?
It does, Your Honor.
That is a Thursday.
Yep.
Hear you.
Mr. James, will that work with your schedule? Mediation at 8:30?
It will. Thank you.
Okay.
That
So
will be a
would
different
that be-
mediator, Mr. Goldman. That will be Ms. Brower.
Okay, thank you for letting me know.
Okay, we'll provide you with Ms. Brower's Zoom ID number. It'll be a Zoom mediation. Mr. James' personal mediation is to assist you and your wife to address issues, to work out your own agreement resolution. It's not binding, so go into it with open mind that you're going to resolve and work out your own differences. Obviously, if there's real estate, I don't know who's living in the real estate.
Mrs. James is.
All right, so who's making the mortgage payments?
Mrs. James.
Okay, is she capable of refinancing?
I believe it's held entirely in her name.
Oh, so the mortgage and title's in her name?
Yes, and it was purchased post separation, but it is presumptively marital property.
Okay, all right. That makes it a little cleaner. All right, and then finally, there is an issue. Ms. James is public assistance. Mr. James, you are employed. I see you've got a UAW shirt on. You're gainfully employed. Is that correct?
Correct.
Okay, I'm just letting you know the court will order that you pay the $255 filing fee, and we'll discuss that. That's going to be addressed in any judgment. Ms. James is on public assistance. She has legal services, so the clerk of the court waived that filing fee, and the taxpayer should have to pay for this. So the court will ultimately order you to pay that. It's $255 payable to the county clerk. You can pay that between now and October 17th. Then we do not need to address on the judgment. So make a note. You can pay by credit card over the phone. They're going to charge you a couple % fee, but otherwise you can just walk in and pay cash $255. It's called the divorce filing fee. So I will raise that to when we come back on October 17th. Court would appreciate if you can get that taken care of between now and then.
Yes, Your Honor.
All right. Any questions, Mr. James?
No, not at this time.
All right, Mr. James, let me just make sure we've got your current address is correct.
That is correct.
Right. Mr. Goldman, anything further?
Yeah, Your Honor, if we are able to get a consent judgment or divorce signed before the 17th, are you able to get us on the record?
Absolutely.
Okay, very good.
Absolutely. We can do it. Absolutely. We can do it even before then.
Okay.
Probably been separated too long. The court be inclined to waive the statutory 6-month waiting period. Yes, we can enter a judgment divorce before the end of this month. If in fact the parties have agreed upon entry of consent judgment, just a matter of calling my office, Mr. Goldman, and we can give you a date. We don't need to send out notice. If the parties can communicate and set a time, they can zoom in. It won't take but 10, 15 minutes. Then we can vacate the mediation dates.
Very good. Thank you.
Okay, so Mr. James, keep in contact with Mr. Goldman. He's trying to help facilitate resolution. As a matter, he'll ultimately prepare a judgment divorce. If the two of you have an agreement, we don't need to fool with mediation October 17th. But otherwise, mediation October 17th, 8:30 in the morning, and the party shall appear before the court for a pretrial immediately thereafter.
Sounds good, Your Honor. I'll be awaiting on Mr. Goldman's email.
Okay, all right. If there's nothing further, I will conclude this pretrial. We can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you.
Thank you. In the matter of Sarah James versus Stephen James.
For the record, this matter is before the court for continued pretrial conference subsequent to the parties having engaged in mediation with Ms. Barr from the front of the court. This hearing is being conducted via Zoom. President is Attorney Alex Goldman. Representing the plaintiff, Sarah James. Ms. James is present. In addition, defendant Stephen James is present. Good morning, everyone.
Good morning.
Good morning, Judge.
The court has been informed that Mr. James paid the requisite filing fee yesterday. So thank you, Mr. James, for taking care of that. We don't need to address that in the judgment.
You're welcome.
Mr. Goldman, the court has been informed the parties have reached their own agreement this morning. Is that correct?
That's correct, Your Honor.
Okay, wonderful. Mr. James, the court's going to have Mr. Goldman state on the record what he understands to be your agreement. So listen carefully. And I trust you made some notes. And after he does, I'm going to turn to you and ask you whether or not he's accurately stated your agreement. Okay?
Thank you.
You're welcome. All right, Mr. Goldman, if you could please state what you understand to be the party's agreement, please.
Thank you, Your Honor. Neither party will receive spousal support, and that is a permanent waiver. Mrs. James will be awarded the home free and clear, located at each party will keep the personal property currently in their possession. Each party will be responsible for any debts in their own name. Mrs. James is awarded the 2018 Chevy Equinox. Mr. James is awarded the 2017 Dodge Journey. Mr. James will keep the entirety of his retirement account. Mrs. James will not receive any portion of it, and Mrs. James does not have a retirement account. The parties have agreed on the following parenting time schedule. Mr. James will have overnight parenting time every other week from Thursday after school until Sunday at 7 p.m. And if there is no school, that parenting time begins at 3 p.m. He will also have non-overnight parenting time every Monday and Tuesday from after school until 7 p.m. And for all parenting time, the parent who is beginning their parenting time will be responsible for picking up the children. During the summer, the parties will follow a week on, week off parenting time schedule with exchanges happening Sundays at 7 p.m. And the parties will follow the Monroe front of the court holiday schedule. There is an existing support case, 153950DS, that will be consolidated into this case. Ms. Brower did calculate run a new calculation with the assistance of the parties, and they agreed to it. So there will be a new uniform child support order that results in Mr. James paying Mrs. James $741 a month. That new UCSO will be included in the judgment of divorce that I prepare and file. The effective date of that new child support order will be December 1st, 2024. Mrs. James will claim both children as dependents on her taxes. And that is the entirety of the agreement.
Thank you, Mr. Goldman. And again, the parties will have joint legal custody. Is that correct?
Thank you for clarifying, Your Honor. Yes.
Mr. James, did Mr. Goldman accurately state your agreement this morning?
He accurately did.
Very well. Mr. and Ms. James, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. Mr. Goldman, you can begin with Ms. James, so you can take take the proofs and then confirm with her this agreement, please.
Thank you, Your Honor. Sarah, can you please state your full name for the record?
Sarah Ashley James.
Did we file for divorce on June 23rd, 2024?
Yes.
At that time, had you lived in Michigan for 180 days?
Yes.
And had you lived in Monroe County for 10 days?
Yes.
Has there been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Is there any chance that you're pregnant today?
No.
You and Mr. James shared 2 children, correct?
Correct.
And did we spend significant time this morning discussing an agreement during mediation?
Yes, we did.
Did you have adequate time to fully consider that agreement?
Yes.
And did the terms of the agreement I just read accurately reflect that agreement?
Yes.
Do you have any questions about that agreement?
No, sir.
Do you think that those custody and parenting time terms are in your children's best interest?
Yes.
And do you think that the property division is fair and equitable?
Yes.
Do you understand this is a final property division?
Yes.
And do you understand that your waiver of spousal support is permanent?
Yes.
Do you understand that we could have gone to trial on these issues?
Yes.
And that it could have actually gone better, it may have gone worse, or it could have gone about the same?
Yes.
And you are giving up your right to trial on those issues by entering this agreement?
Correct.
And you're asking the court to approve this agreement today?
Yes, sir.
And are you asking that the court waive the 6-month waiting period and just approve the divorce today?
Yes.
Will finalizing the terms today, waiving that 6-month waiting period, allow everyone, including the children, to move forward and begin to adjust to the changes contained in this agreement?
Yes.
And you do not want to change your name, correct?
Correct.
Nothing further, Your Honor.
And Ms. James, you and your husband have been separated for about the last 9 years. Is that correct?
That is correct, sir.
All right. It appears that a waiver of the statute of waiting period would be appropriate due to the fact that the parties separated for such a long period of time. And the 6 months time frame does not expire until December. There appears to be no reason why the parties should not to be granted immediate relief in terms of a judgment divorce. All right. Mr. James, can you please state your name and current mailing address for the record?
Stephen Michael James, 727.
Thank you. Mr. James, did you hear the testimony of your wife, Sarah, this morning?
I did.
Was her testimony true and accurate to the best of your knowledge?
It was.
Do you have any questions for the court?
Not at this time.
Do you have any questions for Mr. Goldman?
Not at this time.
All right. Mr. Goldman, do you have any questions of Mr. James?
No, Your Honor.
Mr. Goldman, will you submit a proposed judgment to Mr. James for his review and approval, or you submit them to the 7-day rule?
I will draft it as a consent judgment of divorce and circulate to everyone for signature.
Do you have an email address for Mr. James?
I think I do. Let me double check.
S. James.
That is correct.
Yep, I've got it. Thank you.
All right. So, Mr. James, Mr. Goldman's going to prepare a proposed judgment of divorce. And of course, there'll be some standard required provisions in this judgment that you didn't talk about. For example, you're going to comply with the Hague Convention. You cannot take the children to a country that will not enforce parental kidnapping laws and so forth. But he's going to send to you the proposed judgment for review and approval. If you have any questions, call him. And then once you've approved that, you got it back to Mr. Goldman. Mr. Goldman will submit it to the court for entry. I'm sorry, one last thing. Is Ms. James requesting restoration of former name, Mr. Goldman, or is she going to keep the name James?
No, Your Honor, no name change.
Okay. All right, the court would like to thank and acknowledge Ms. Brar for her assistance this morning, as well as, of course, Attorney Goldman for helping facilitate amicable resolution between the parties. The court would applaud the two of you, Mr. and Mrs. James, for reaching your own agreement. It's wonderful you can co-parent your children. They will do well. Now saying divorce, they will do well if you're on the same page for their benefit. So the little things are important. For example, mom always to make sure the kids get a Father's Day card for dad, and as Father's Day, those things mean a lot to children. Likewise, dad, when it's Mother's Day, make sure the kids make sure they have a card for mom. That really means a lot to the children.
Yes, Your Honor.
So,
Will, Your Honor.
And communication is the key. I mean, there's enough challenges in life. Don't make it more difficult for each other. If you need to be flexible on parenting time, if someone's running late or there's something special going on, you want the children to work together on those kind of issues. In any event, based on the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the obvious matrimony had been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, upon receipt of the consent judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce from the bonds of matrimony. That will conclude this hearing. Good luck to both of you. You can all zoom out. Have a good rest of the day.
Calling the matter of Brian Derard versus Crystal Collins.
For the record, this matter is before the court for a pretrial conference.
Good morning, Judge.
This court's order was that this be an in-person pretrial conference.
Oh,
this morning, sir, you are Brian Derard, is that correct?
Yes.
Right. And Mr. Rodenberg, you're in your office?
I'm in my office, but I can run across the street if you want.
And once you do that, I would like, obviously, first of all, I've got the proposed judgment. You have not approved it, nor has Mr. Derard approved that. I'm sorry, you have approved, but Ms. Collins has not approved it. Do you have a copy that she's approved the judgment?
If you give me 15 minutes, I can produce Ms. Collins. Can we adjourn this for 15 minutes? I'll drive to get her and then bring her into court.
Okay,
I was
so many
told
outstanding issues. Hold on, there's so many outstanding issues. That's why the court wanted this in person. We can sit down face to face and hash out these remaining issues. And if we need to have the court come up, we can do that.
I was confused as to whether or not we were in person, Judge. I will go. May I?
Your pretrial notice. Pretrial notice says final pretrial conference scheduled for this court on Friday, September 13th, 10 a.m. In person.
I was told.
My bad. I own that. I screwed it up, Judge.
Okay. All right. Right. Mr. Derard is here.
I was told I could.
Let me run across the street, Judge. I'll see you in about 2 minutes.
Ms. Collins, if you cannot come to court and you're some ways away, you can appear by Zoom. At least we have Mr. Rodenberg, and we can have Mr. Rodenberg and Mr. Derard talk with you on the Polycom here in court.
I would have to walk or take a bike, and I'm like almost.
Crystal, you can stay home. It's okay.
Okay.
Stay home. But why don't you put you in a waiting room? Ms. Collins, put you in a waiting room so that we can consult with you if necessary. So just stay in your waiting room, and hopefully we can pull you back out in about 10, 15 minutes. Okay?
Okay, sounds good.
Okay, I'll see you in a minute. Sorry about that, Judge.
Thank you.
Versus Crystal Collins.
For the record, again, this matter is being recalled. It's before the court for continued pretrial conference. Attorney Stephen Rodenberg, representing the plaintiff, representing the defendant, Crystal Collins, is present personally, along with the defendant, Brian Derard. Ms. Collins, the defendant, is present on the Polycom, appearing via Zoom this morning. Good morning, everyone, again, and thank you, Mr. Rodenberg, for coming over on short notice.
Privileges of having an office in the courthouse square, Judge. It worked.
As Mr. Derard, have you gone through the judgment? Has Mr. Derard approved the judgment?
Yes, we did a couple minor alterations. I put my address on there. There was some changes penciled in, like the word date was in there. There was around paragraph 26. We had a 26, we had a 26A. Okay, I didn't really count the paragraphs, so I see they're numbered. Okay, I do see 26A. Okay. Paragraph 37 was changed to 27 because there was a typo there. Okay. So there were things like that. The parties shall remove each other's names from insurance policies as needed forthwith. Okay. It was a minor thing.
I just spotted another little typo that I had on page 30, but it's a spelling error. It's a spelling error. It doesn't change things. I believe we're covered. Oh yeah, and the motorcycle trailer was struck from the judgment because he says he no longer has it.
And I see that, Mr. Derard, and you have both initialed that.
Yes.
You've also changed the office address. Hopefully the small print can be picked up by the clerk's office, so email you a true copy.
If you'd like, Judge, I could run across the street, print out a new one, and we can just append it to it.
Okay, I'll leave that to you. All right, Mr. Derard, you have reviewed this morning with Mr. Rosenberg and assistant at the front of the court every page of this judgment of divorce. Is that correct?
Yes, I have.
And are the terms and conditions consistent with the agreement previously reached? Yes. Okay. Do you have any questions for the court?
No.
Okay. And obviously, Ms. Collins also participated in your discussions this morning. Is that correct, Mr. Rosenberg?
Yes.
All right.
There is one other thing that my client reminded me of. We're gonna, I guess we'll enter it under the 7-day rule. We still have to enter an order to the front for the front of the court to interview the minor children. For the front of the court to interview the minor children, because there's an issue with reintegrating parenting time. There was a gap of a few months where Mr. Derard didn't see the children, and
do the children not want to see their dad?
There's been some issues where they don't want to, and there's been some issues where he seems to have not wanted to, and we just, the children are entitled to have a relationship with their parent and know who they are. So we're just trying to make sure that they do that. Yes, Chris? Oh, hi.
Judge, can I tell you something? After our last hearing, July 26th, I did let the boys go see them for the weekend. Logan come home. I did never
Logan's
call.
the oldest, Judge.
Yeah. Logan came home. I'd been on him for about a week to clean his room. After he came home for the visit, he's yelling and screaming at me, "F you, you crazy bee. Better shut up or I'm going to beat you like dad used to." I let him see him.
Some behavioral problems, basically.
So I decided to wait a weekend. I let him see him the following weekend. And he came home and did the same thing. F you, you MF, you crazy bee, after he's seen his dad. I let Logan and all of them see them on Logan's birthday, August 17th. Because of what Logan had said and the threats, I stopped the visitation until we can talk to the parenting worker.
Okay, the judgment of divorce does indicate that the parenting time is reasonable and liberal. And if two of you cannot agree, then obviously, Mr. Gerard, you need to petition the court for a specific parenting time schedule. But this judgment also says that parenting time is referred to the front of the court for formal report and recommendation. So, Ms. Patrick, when the judgment's entered, the front of the court will send out questionnaires for both parties. Is that correct? As part of their standard parenting time recommendation?
That's correct, Your Honor. But the front of the court will not interview the minor children unless that's specifically indicated in the order.
Okay.
So you want a specific order drafted for that?
It needs to be added to the judgment. The children are ages 10, 12, and 15. So they're obviously old enough to be subject to interview. Mr. Gerard, obviously, you got to tell the boys got to respect their mom. Just like mom should be telling the kids that they respect their dad. It's their dad. You need to tell them if they're acting up that it's not permissible. It will not be tolerated. They need to respect their mother.
Right.
So you need to do that. If he's calling inappropriate names after spending time with you, you need to put the kibosh to that.
Yep.
Do you have any objection to the children being interviewed?
No, but I did go over there when she called me and told me what was going on, and I got him calmed down. And
he was already on the phone.
Right. So, Mr. Rodenberg, Mr. O'Droyd has no objection. So, why don't you write in the judgment and have them both the initial that the last on paragraph 4, numerical paragraph 4, the last sentence says parenting time referred to the court for own. You can put the parties agree that the children shall be interviewed. Parties agree that the children should be interviewed. Then you can both initial that. That will avoid having to prepare a separate order.
Are there any other alterations to page 3? Because if not, we can just do it. We can just
It's right in there, and both you can initial that. So the children will be interviewed to their preference. But Mr. Ard, again, I obviously don't want children that are disrespectful to adults or authority. But we need the entire judgment.
That's the exact thing.
Understand?
It's a 1-for-1.
Right, but I don't sign each page of the judgment.
Oh, okay, no, but if Judge, if I'm going to be retyping or switching anything with that one,
Right. Once you give me, do you have a full judgment that's been approved by both you and Mr. Derard? If you hand that to me.
You have that. So that's why I'm switching up.
I'll give everything I've got. Mr. Derard has not approved this judgment, so I don't know what other changes he made. This is a copy. I don't know. I want a copy that's been approved by Mr. Gerard. So I'm gonna give that back to you and get it all together, and then you can send that to court for signature. And Mr. Gerard, do you have any other questions?
No.
Okay. If you want to wait around, Mr. Weber will get that together, and we can provide you with a copy of his judgment. All right, Ms. Collins, the children will be interviewed as part of the parenting time recommendation. So you both be mailed, keep the front of the court informed of your address. You will both be mailed the questionnaire, you fill that out. They will generally conduct a phone interview with each of you. And then obviously they will also interview the children. They'll probably all be interviewed together. All right, if there's nothing further, I will conclude this pre-trial conference. Ms. Collins, good luck to you. You can zoom out.
So leave meeting?
Yes.
Good
luck.
Oh, did we ever take the proofs in this case? I think we did.
Yes.
So yeah, once this is ended, you guys will.
I just wanted the parties to appear today so what you could do like you just did and type these loose ends. So I appreciate you coming over.
Judge, may I present
And retirement benefits, there are no retirement benefits, correct? The judgment does not address that. Okay. Is that correct, Mr. Gerard? You don't have any retirement benefits?
No.
Okay.
That's correct.
Matter of Jerry Haynes versus Aisha Haynes.
For the record, this matter is before the court this afternoon for a pretrial conference. The same is being conducted via Zoom. Appears both parties are present. Sir, you're Jerry Haynes, is that correct?
Yes, sir.
And ma'am, you are Aisha Haynes, is that correct?
Aisha Haynes.
Okay, good afternoon.
Good afternoon, sir.
Court is in receipt of a proposed consent judgment that both of you have approved. Can you both please raise your right hand to be sworn, please?
Could you please repeat for what?
Can you please raise your right hand to be sworn? Do you both solemnly swear affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. We'll start with you, Mr. Haynes. You're the plaintiff. Can you please state your name and current mailing address for the record, please?
Yes, sir. My name is Jerry J. Haynes.
Thank you. Mr. Haynes, is it true that you filed a complaint for divorce with this court on about June 12, 2024?
Yes, Your Honor.
Is it further true that on the date you filed the complaint, you've been a resident of the Monroe, State of Michigan for at least 6 months?
I'm sorry, a resident for what?
Is it further true that on the date you filed that complaint, namely June 12th, that you've been a resident of the Monroe, State of Michigan for at least 6 months?
Oh, yes, sir. Yes, sir.
Is it further true that you married Aisha Razulzade? I can't pronounce her last name.
Yeah.
Razulzade. In November of 2017, you separated in August of 2023.
Yes, Your Honor.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable chance of reconciliation?
Yes, Your Honor.
Were there any children born or adopted during your marriage who are still minors?
No, sir.
And you signed your name to this proposed judgment approving the terms and conditions contained therein, is that correct?
Yes, Your Honor.
Right. Ms. Aisha, do you have any questions for the court? Or I'm sorry, can you please state your name and address?
The Mamedov building 1 and number sign 20 Baku, zip code is A1000 Azerbaijan.
Where is that?
Azerbaijan.
What country is it?
It's border with Turkey and it's nearby the Caspian Sea, border with Armenia. It's a Caucasian country.
Yeah,
Okay.
the country's name is Azerbaijan, Your Honor.
Okay. Thank you. It's a small country, is it?
Right.
Okay. All right. Ms. Aisha, did you hear the testimony of your husband, Jerry, this afternoon?
What
Did you hear Jerry's testimony?
testimony is the, could
Did
you
you hear his
please?
statements? Did you hear what he just said?
Did you hear what I'm sorry, Your Honor, I know how she understands sometimes. Did you hear what I told the judge?
Yes, I did.
Okay. All right. Was that all true and accurate?
Yes, sir.
Are you currently pregnant?
No, sir.
And did you sign your name to this judgment approving the terms and conditions contained therein?
Yes, sir.
All right, the court's gonna go through this with both of you together. You've agreed that spousal support is not awarded, it's forever barred. You've already divided your personal property, so each will keep the personal property currently in your possession.
Only my question is that what was the first question is that about the complaint I heard? What was that, Jerry? You said that, yes.
May I answer, Your Honor? I don't know proper procedure.
Yes, go ahead.
So he's asking the complaint, the paperwork that you signed and sent to me and I delivered.
Okay.
Did you sign those paperworks? And now, if again, please, Your Honor, if I'm overstepping, please let me know. He's going over those that document.
Gotcha.
Okay, so you've agreed, you've already divided your personal property. So each will keep the personal property currently in your possession. There's no real estate to be divided. Each will keep their own automobiles. Each will keep their own retirement accounts. With respect to debts, the judgment says debts are divided according to the attached personal property and debt addendum. There is no debt or personal property addendum.
What?
So are there any joint debts, Mr. Haynes? Debts in both names?
So like her FAFSA account, I was co-signer for it because I was the one who worked. And it's tied to my bank account as well. So that is a joint debt, and admittedly, I promised to pay that off for her because, truth be told, they'll come after me. But also, she went to college because I pushed her to go to college.
Okay, so there is no debt addendum attached. I know there's just a piece of paper. It's a dashboard that says FAFSA, but it doesn't indicate any names or anything. So what the court should do is write into this judgment, write a term that you agree to pay the balance of the loan due to that was applied through FAFSA. But who's the loan to? What's the name of the financial institution?
To be honest,
you don't make payments to FAFSA. FAFSA is just the
right. To be honest, top of my head, I do not know, Your Honor. It's been one of those. Her account's been on hold because of the President Joe Biden and such. But it is.
So does he ask how much I have a debt?
No, he's asking who is holding your loan, the FAFSA loan. And I already, admittedly, I made one payment. This was February of this year.
Who did you make the payment to, Mr. Haynes?
I can't remember because I just go into her FAFSA account, click to the loan holder, and then made a payment. I haven't done that since, so I do apologize, Your Honor.
Mr. Haynes, you've agreed that you're going to pay the balance of that loan. It's about what, $9,000-$10,000. Is that correct?
Yes, sir.
Okay, so I can write in the judgment that the plaintiff, Jerry Haynes, agrees to pay the outstanding balance of a student loan for the benefit of your wife.
Yes, Your Honor.
Would that be accurate?
Yes, Your Honor, that would be.
And we don't have an account number. We don't know to whom it's owed, but there's just one student loan, correct?
Yes, Your Honor. It's only one student loan.
And the balance is approximately almost $10,000, correct?
Yes, Your Honor.
Okay, so if I can write this in the judgment and I'll put my initials next to that, is that acceptable?
Yes, Your Honor.
Okay. Are there any other joint debts, Mr. Haynes?
She is currently in an IT course that she pays monthly. You would have to ask her questions because I don't understand it that well.
Well, I can't be your attorney, Mr. Haynes. I'm trying to help you out with the judgment divorce, but you need to spell us out in judgment divorce.
So I promised to pay a IT training course that she is currently in her country. That is $4,000 US.
Mr. Haynes, you need to. I'm not going to enter this judgment divorce and prepare this for you. You need to attach to it a debt addendum and spell all this out. You've not done that. you go online, you get the forms. You can come down here, we get you a form. You need to fill that
This
out.
is the verbal agreement and just the tutor, and I'm given the cash. That's why there was no paper I can send him to, and it's just between us, the verbal agreement. And when we are married, he promised me he will pay for my bootcamp for my development, and now he's doing it. It's yeah.
All right, so so there's two joint debts that you agree to pay, Mr. Haynes, is that correct?
Yes, Your Honor.
The student loan, can you find out who it's doing payable to?
Yes, sir.
Research to be paid in February. That'd be nice if we could spell this out. So there's not. I don't want. Of course, trying to avoid issues down the road.
I understand, sir. I do apologize.
So you can either go online and then print out what's called a debt addendum, or you can come down here and we can try to print one out for you. If you want to come down to the courthouse.
Okay, I can print one out, sir.
Okay, and spell it out. Put it right in there that that you as a plaintiff agreed to pay in full the outstanding indebtedness for defendant's student loan. And if you find out if it's due to Chase Bank or whoever it might be, that always helps. But if you can, just say the student loan and also this IT. I don't know, what does IT stand for? Information technology?
Information technology, yes, sir.
Okay, and who is that loan to?
The name of the boot camp. I shouldn't.
The boot camp is the Hayward.
Did you capture that, Mr. Haynes?
I captured it. It sounded like Hayward. For this one, Your Honor, I'm unsure. And for the debt addendum, do I just put $4,000 for?
So the boot camp will take approximately 8 to 10 months. It's just approximately 4,000 because it can take 8 or 10. It depends how the progress goes. My tutor said.
So did the two of you communicate via email?
Yeah,
Okay.
Yes, Your Honor. We communicate.
Okay.
Rather,
So the
rather
two of you
frequently.
two of you can, when we're done here, communicate, email, and then try to exchange this information so you can be as specific as possible in this debt addendum.
Yes, Your Honor.
So just two debts, FOSFA debt and IT debt.
Yes,
This is
Your
what
Honor.
you say it's a boot camp?
Yes, boot camp, sir.
Wow. What is it, a physical fitness camp?
It's like and I can answer because I've been in one as well. It's like a information technology crash course. You do roughly a year to 2 years of work in 8 months to 1 year time. It's used a lot for learning a certain system or a certain application. Hence why they say like a boot camp, kind of like military, a short training.
Short intensive course, right? But you agree to pay both those debts, correct, Mr. Haynes?
Yes, Your Honor.
Okay, you got to spell it out in an addendum, and then you need to bring that to the court or on the 4th floor.
Okay.
So the judge wants something from the boot camp, if I understand correct.
Permission to answer, Your Honor?
Yes, please, go ahead.
The judge is wanting me to fill out an addendum form, a specialized form that has the information about the debt. So the boot camp debt, the FAFSA loan.
So you have to fill the something form from the
and bring it to the court. So they know exactly what debts are owed.
And that piece of paper will be as part of this judgment. So we incorporate the judgment so that organization, you are protected. He's going to pay those debts.
Thank you so much.
Okay.
I appreciate.
Right. Do either of you have any other questions?
I have questions, sir. So when I got my US citizen, I changed my name to make like English version, Aishan to Aisha. Now, can I go back to my previous name to Aishan and my maiden name to Rasulzadeh? That's automatically changed. I know that's not a problem, but can I change my name, first name?
Yes. In the judgment on page 2, if you got a copy, it says that your name shall be changed to Aishan, Ayshen, Rasulrade. Is that correct?
Yes, Rasulzadeh. Yes, sir.
Okay. So when you receive this judgment, you need to take that to Bureau of Motor Vehicles or Secretary of State Social Security, whoever, and then that will facilitate the legal change of your last name.
Thank you, sir. So how long will take that and I will get the paper?
Ask Mr. Haynes. He has the court will sign it. You'll be divorced once the court receives that done. If he wants to bring it up this afternoon, I'll sign it this afternoon. If it's up next week, it'll be next week.
Okay.
Mr.
Also,
Haynes, you just go online and determine the nature of those. I find the attachment. It's called a personal property and debt addendum. If you can't find it, you come down here to the 4th floor Bronx office. We'll see if we can help you out with that form. You need to fill that in. Reference as much information you had to specifying those 2 loans that you agreed to satisfy.
Yes, Your Honor, I will.
Ms. Asian, another question?
yes, sir. Also, can I change my U.S. passport in U.S. Embassy in Azerbaijan? Is it possible? Do you know about that or not?
I do not know about that. That's something you have to ask the embassy.
Okay. Okay.
Okay. All right. So the court's going to hold this judgment until we get that addendum. It's a one-piece addendum. Mr. Haynes, you can spell the 2 loans and bring that down, and the court will then sign the judgment. We'll mail a copy to both of you. Based upon the testimony that's been presented this afternoon, as well as plain file in this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown of the marriage relationship to the extent that the opposite matrimony has been broken. There appears to be no chance of reconciliation. Accordingly, upon receipt of the addendum, the court will sign the judgment of divorce, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter, granting a divorce from bonds of matrimony. All right, that will conclude this hearing. Good luck to both of you, and you can both zoom out.
All right. Thank you, Your Honor.
Thank you.
Welcome.
You're
welcome.
Have a good day.
Oh, okay. Okay, get the file. I thought you said it was up here.
I'm sorry.
Okay.
Is that here?
Oh, that's not.
Yeah, I think I might have.
Okay, why don't you grab real quick and I'll look for it. Why don't you bring them in here?
Calling the matter of Keith Poor versus Ashley Poor.
And for the record, parties are before the court, apparently have engaged in mediation with Mr. Godfrey this afternoon. Present via Zoom this afternoon is attorney Kirsty Nemec, representing the plaintiff Keith Poor. Mr. Poor is present. In addition, attorney Maria Zagorski is present, representing defendant Ashley Martin, and Ms. Martin is present with Ms. Zagorski. Good afternoon, everyone.
Good afternoon. Good afternoon.
The court's aware that the parties have been working, trying to resolve this issue of school choice between themselves. There's Mr. Godfrey, who just appeared. Ms. Nemec, have the parties reached their own agreement to avoid a hearing on this matter?
Yes, they have.
Wonderful. Who would like to place that agreement on the record?
Judge, I'll take my stab at it. We have one minor child that is applicable here. It is Josie, born in 2018. The minor child would attend elementary school at the Eiler Elementary School in the Airport School District in Michigan. Mother shall be in charge of enrolling the child at that school. As part of the contact information, father's information should be inputted as well. Whether mother's first contact or doesn't matter, but as long as dad's contact information is included there as well. And that would be commencing forthwith. I'm not sure. Hopefully we can get the child in, if not yet today, Monday. The tax exemption, the parties have agreed for this allocation for state and federal income tax purposes. Father would claim for years 2024 and 2025, and thereafter every odd year. Mother would claim in 2023 and every even year thereafter. The tax allocation would be part of a child support provision and therefore subject to modification by the court. That the parenting time in the judgment merely said reasonable and liberal. I believe the parties have reached an agreement on what they're specifically doing, and that is as follows. Week 1, father would have Sunday, Monday overnight. Mother would have Tuesday, Wednesday, Thursday overnight. Father would have Friday, Saturday. Week 2, mother would have Sunday, Monday. Father would have Tuesday, Wednesday, Thursday, and mother would have Friday, Saturday. The exchange time is going to be 6 p.m., but they're going to use that as best they can. I just, as a mediator, use 6 p.m., so I told them I'm going to put 6 p.m. on that. On Mother's Wednesday overnight, so the week that she has Tuesday, Wednesday, Thursday, father may pick up the minor child from after school, pick the child up from school, and have the child until 6 p.m. It's not overnight. It's just a block of 3 hours on that Wednesday that mother has Tuesday, Wednesday, Thursday. There would be a savings clause put in indicating that all other provisions of the judgment of divorce that are not inconsistent herewith shall remain in full force and effect. That is the agreement, Judge, I believe.
Thank you, Mr. Godfrey. Ms. Nemick, did Mr. Godfrey accurately state the agreement?
He did.
Ms. Zagorski?
Yes, that is the agreement. Thank you.
Thank you. Wonderful. Mr. Poor, Ms. Martin, can you both raise your right hand to be sworn, please? Do you both solemnly swear affirm that the testimony you're about to give us matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. Ms. Nemick, you're going to begin with Mr. Poor, please.
Yes. Keith, can you state your full name for the record?
Keith Kennedy Poor.
And you are the plaintiff in this action, correct?
Correct.
Did you hear the agreement that Mr. Godfrey read into the record?
Yes.
Did you understand it?
Yes.
Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Is anybody forcing you or coercing you to enter into it?
No.
Okay. Do you believe that it's in Josie's best interests?
Yes.
Okay. Do you understand that by placing this agreement on the record today, that makes it binding on you, even though we haven't turned it into a written order? By putting it on this record before the judge, you are bound by the agreement.
Yes.
Okay. And you understand that you could have taken this matter to trial and the outcome could have been different.
Yes.
But rather than do that, you're asking the court to take the agreement as Mr. Godfrey read into the record and make it an order.
Yes.
You understand that you had the right, if we were going to continue with this process, to conduct further discovery, maybe find out other things that might have changed your mind, and you are waiving that right by entering into this agreement.
Yes.
Do you have any questions at all about the agreement as you sit here today?
No.
Okay. And are you satisfied with my representation?
Yes.
Okay. I have nothing further.
Thank you, Ms. Nemick. Ms. Zagorski, do you have any questions for Mr. Poor?
I do not. Thank you, Judge.
Questions for Ms. Martin, please?
Yes, thank you. Would you please state your name for the record?
Ashley Marie Martin.
And similarly, you heard the agreement that Mr. Godfrey read into the record?
Yes.
You understand it?
Yes.
You understand that if the court adopts it today, you will be bound by it?
Yes.
Do you believe that everything that we are agreeing to is in your child's best interest?
Yes.
And you're asking the court to adopt it today?
Yes.
And do you have any questions about it?
No.
You understand that there was a mediation, so there was some give and take, correct?
Correct.
But you're satisfied that Josie's needs are being met?
Yes.
Okay, and similarly, you understand this matter is set for hearing on Thursday. The judge could have done something different, including not necessarily making any financial findings, things like that, but you're okay with this?
Yes.
Okay, and I'm sorry, any questions?
No questions.
Okay, thank you. That's all I have, Judge.
Thank you, Ms. Zagorski. Ms. Nemick, do you have any questions of Ms. Martin?
I do not. Thank you.
Okay, who will prepare the order?
I'm happy to take a stab at it. We can do it by consent, Judge.
All right, thank you, Ms. Zagorski. Very well, with this agreement on the record, the court will vacate the full day hearing schedule for Thursday, September 19th, 2024. The court would like to thank Mr. Godfrey for his assistance.
Yes.
Particularly Attorney Zagorski, Nemick, you're very good family law practitioners, and the court appreciates your wonderful advice to your clients. And Mr. Poor and Ms. Martin, obviously in preparing for this, the court recognized I have two incredible, wonderful parents here that are truly vested in the welfare of their daughter. And obviously with this agreement, that shows the court even more that the two of you are wonderful parents and that you can ultimately agree upon what's best for her. Now saying what each of you would individually prefer, but what's best for her. It's obviously a difficult decision. There's a lot of emotions with it, but it certainly shows your strength and your resolve as parents to work together, no matter what issue might come up between now and when Josie's an adult. So you're going to be able to agree upon that, because the reality is, you know what's best for her better than anyone in this world. You don't want a stranger making these decisions. So the court sincerely applauds both of you. And again, thank you, Ms. Zagorski and Ms. Nemick, for your assistance in guiding the parties. The reality is when we have hearings, Ms. Martin, Mr. Poor, it hurts feelings. People are throwing stones at each other, and very often it deteriorates an otherwise good relationship. So the court sincerely applauds both of you. The court finds this agreement to be in the best interest of the minor child, Josie, and the court will adopt that agreement and enter the order upon presentment. Things can change in the future. But again, for right now, it does appear to be in her best interest. So with that, thank you again to Mr. Zagorski and Mr. Niedermeck and Mr. Godfrey. That will conclude the hearing. You can all zoom out.
Thank you.
Thank you, Your Honor.
Thank you. Appreciate it.
I hope Josie has a great first year.
Thank you.
Thank
You're
you.
welcome. Oh, that opens up for Thursday. But I wish I could say more. I don't know what else, but I think it's wonderful. They can, it was hard. They're like both equal, very hard, both actively engaged, very active in their daughter's life, 5-year-old. And it's, of course, he wind on. That's good news. I'm going to give Andrea off on Thursday.
Yeah, right.
You can leave early today, though. Henry's not here.
Good afternoon, Linda. I'm going to check to see a sound check with Miss Carey. Is she here? Okay. Miss Carey?
Yes, I'm on the phone.
Wonderful.
Linda Tamina versus Carrie Tamina.
For the record, this matter is before the court this afternoon for a pretrial conference, the same as being conducted via Zoom. Court is in receipt of what appears to be a consent judgment of divorce. Ma'am, can you state your name for the record?
Linda Taramina.
Okay, thank you. And Carrie Taramina, you're also present on audio, is that correct?
Yes.
Both please raise your right hand to be sworn, please. Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Yes.
Thank you. We'll start with you, Miss Linda. Since you're the plaintiff, can you please state your name, current mailing address for the record?
It's Linda Taramina.
Is it true, Miss Linda, that you filed a complaint for divorce with this court on about June 14th, 2024?
Yes, it is, Your Honor.
Is it further true that on the date you filed the complaint, you have been a resident of the County of Monroe at least 10 days, the state of Michigan at least 6 months?
Yes, sir.
Is it further true that you married Carrie? The complaint doesn't say when, it says June 2nd. I don't know what year it was, but you married Carrie.
2017.
2017, and you, when did you separate?
It was the beginning of June.
Okay. Is it true, ma'am, there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed, there's no reasonable chance of reconciliation?
That is correct.
Were there any children born or adopted to you during the marriage?
No, there isn't.
And you signed your name to this proposed judgment approving the terms and conditions contained therein, is that correct?
That is correct.
Okay, Miss Carrie, can you please state your name and mailing address for the record?
Carrie Taramina, 111.
Thank you. Miss Carrie, did you hear the testimony of your spouse, Linda, this afternoon?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes, it is.
And you also signed your name to this proposed judgment approving the terms and conditions contained therein, is that correct?
Yes.
Okay, Miss Carrie, are you currently pregnant?
No.
I need to ask that same question of Linda. Miss Linda, are you currently pregnant?
No.
Okay. All right, I'm going to go through the terms of this judgment with both of you. You both agreed that spousal support is not awarded. That's from regard. You've already divided your personal property. So each will keep the personal property currently in your possession, free and clear of any claim on the part of the other. There are no joint debts. Each paying debts in their own name. Is that correct?
That is correct.
Each will keep their own automobile and paying debt thereon. There's no real property, and there are no pensions, retirement plans to be divided. And finally, Miss Carrie is requesting restoration reform name of Carmack, C-A-R-M-A-C-K.
That is correct.
Is that all accurate?
Yes, it is.
Yes.
Do either of you have any questions for the court?
No, I don't.
I don't either.
Okay. So, Ms. Carmack, when you receive a copy of this judgment, you need to take a copy to the Secretary of State and Social Security to facilitate that legal change of your last name, okay?
Okay, thank you.
You're welcome. Right. Court appreciates your cooperation in this regard, having returned the judgment of divorce. Based upon the testimony that's been presented this afternoon, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter granting a divorce for the bonds of matrimony. Court has signed the judgment. You both been mailed a copy. That will conclude this hearing. You can both zoom out. Have a good rest of the day and weekend.
Thank you.
All right, thank you. You have a good weekend too.
Thank you. Parties are present. The court is in receipt of a proposed consent judgment of divorce. Good afternoon.
Good afternoon, Your Honor.
Mr. Goward, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I do.
Thank you. We'll start with you, Mr. Matthew, because you're the plaintiff. Can you please state your name and current mailing address for the record, please?
Matthew Goward, 13.
Thank you. Is it true, Mr. Goward, that you filed a complaint for divorce with this court on about June 20th, 2024?
It is.
Is it further true that you had been a resident of the County of Monroe for at least 10 days and stayed in Michigan at least 6 months prior to filing?
Yes.
Is it further true that you married Nikki Vett, now known as Goward, on May 18th, 2013? You separated in June of 2024.
Correct.
Is it true there's been a breakdown of your marriage relationship to the extent that the obvious matrimony has been destroyed? There's no reasonable chance of reconciliation.
Yes, it is.
Were there any children born or adopted during your marriage who are still minors?
No.
And you signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
Yes, I did.
All right. Ms. Goward, could you please state your name and current mailing address for the record?
Nikki Lee Goward.
Thank you. Ms. Goward, did you hear the testimony of your husband, Matthew, this afternoon?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yes.
Are you currently pregnant?
No.
I'm sorry?
No.
Okay, it's a necessary question that has to be asked. And did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
I did.
Okay, I'm going to walk through the terms of judgment with both of you to make sure we're on the same page. You've agreed that spousal support is not awarded, and that is forever barred. Personal property is divided according to the attached personal property and debt addendum. And that addendum provides as follows: that the plaintiff Matthew is awarded $13,000 in a cash account at Treasury Direct, as well as cash valued at $58,236 in a cash account at Vanguard, as well as cash in the amount of $4,500 in a cash account at MFCU and HSA. The defendant, Nikki, is awarded all contents of the Ida West property and outbuilding, including tractors, mowers, trailers, furniture, and personal items, as well as cash in the amount of $170,206.14 in a cash account at Schwab, cash in the amount of $10,264 in a cash account at KeyBank, Coas Blue Savings, and cash amount of $49,118.22 in a money market account at Amex American Express Savings. Is that all accurate?
Yes.
Yes, it is.
Okay, so I appreciate you spelling that all out. With the automobiles, you each keep the automobile in your own possession, any debt thereon. There are no joint debts, correct? So each have any debts in their own names?
Correct.
Correct.
No joint credit card debts, okay? With respect to real property, the real property known as 10677 Ida West Road, that is awarded to the defendant, Nikki. She shall be responsible for the mortgage, tax, insurance, and any other debts associated with that property. It's further stated that in its addendum that she shall refinance the home to remove plaintiff's name. And that the plaintiff, Matthew, will sign a quitclaim deed within 30 days of date of entry of the judgment for the benefit of the defendant. And that should be done within 30 days. There is no time frame to refinance. And it normally should be, whether it's 6 months from date of entry. The court can add that language in there. I can initial that. I can any language I add in here. Right now it's open-ended. It just says you can refinance. So that can be 2 years from now, 5 years from now. And obviously, Mr. Goward, you want this off your credit so that you can, once the mortgage has been refinanced, that will improve your credit. And if you want to buy another house. So have you guys talked about a time frame for Miss Nikki to refinance the existing mortgage debt?
We have, and there's funding in place to deal with it until then. Nikki, what do you think a reasonable time frame to enter in here for it would be?
I mean, I'm going to try and, get that taken care of as soon as possible. It just depends on, the current lender and, what they decide to do with it. So I have to,
of course, interest rates are going down. You probably want to give some time to let the interest rates go down. So the suggesting
down to
3%,
which is what we have it financed for.
Yeah.
I don't think so.
And that's why
we had put in place that I couldn't remove any of the funds out of the joint e-bank account until the house is removed from Matthew's name.
Okay, I don't see that written in this judgment. Maybe you two of you have an understanding, which is fine, but there's nothing written in this judgment that provides for that. Oh, I'm sorry. No, I'm sorry. Let me go back. I haven't gone through the second page of his judgment. So let me back up a little bit. Let me get to that. Okay, so we'll come back to this point with respect to.
It's in other provisions, I think on 18.
Yep, I do. I'll get to that. I sort of jumped ahead. Retirement benefits, each will keep their own retirement benefits, whether it's a 401k or pension or IRA. Nikki is requesting registered firm name of Wetter, W-E-T-T-E-R. And finally, there's a provision, other provisions. It says Nikki will retain full control and ownership of MAGCM LLC, its assets and future earnings and liabilities. Matthew will retain full control and ownership of Coas Blue LLC and its assets, future earnings and liabilities. Matthew will retain full control of CQL stock, all future earnings and liabilities. Matthew will retain all capital loss carryover from the previous tax returns. The full value of the Schwab brokerage account should be placed into the Key Bank shared checking account. The Idaho West House mortgage must be paid via that account. Neither party will remove funds or use that account for any purpose until the mortgage is refinanced and Matthew's name is removed from the mortgage or the mortgage is assumed and removed. So yes, I jumped ahead and that is now noted, but we should probably establish a time frame. What do you think? Maybe 6 months would be reasonable?
Well, if she ends up, if the mortgage company gives her a hard time, there's enough funds in there to pay it for years. So we can probably put 5 years on here as a something has to happen date. Nikki, does that seem like a reasonable compromise? Okay.
Of course, that will affect your credit, Mr. Goward, as long as that mortgage is still in both names. You understand? So you want me to? Do you want the court to write language in here that the defendant Nikki shall refinance home within 5 years of entry of the judgment?
Yes, I'm comfortable with that. With the other contractual things that we have in place around this, I'm comfortable with that.
Right, Miss Nikki, is that agreeable with you as well?
Yes, that's fine.
Just so I'm just trying to avoid any issues. The two of you haven't come back to court down the road. Just wanted to tie up any loose ends, and I did note that. So I'm going to write on this addendum, the real property addendum. I'm going to indicate under the statement that the defendant Nikki shall refinance the home, remove plaintiff's name. I'm going to put within 5 years from entry of the judgment, and I will initial that. Do either of you have any questions for the court?
No.
I do not.
The court appreciates your cooperation in detailing all these provisions in the judgment and returning the judgments. Based upon the testimony that's been presented this afternoon, as well as claim filed this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter, granting a divorce from bonds of matrimony. Court assigned the judgment, copy mailed to both of you. Ms. Nikki, when you get a copy of the judgment, you need to ultimately take a copy to the Secretary of State and Social Security to facilitate that legal change of your last name.
Yes.
All right. Well, good luck to both of you. That will conclude the proceedings. You can both zoom out. Have a good rest of the day.
Thank you.
Thank you.
You're welcome. Good afternoon, Ms. Carr, Ms. Vitale.
Good afternoon, Judge.
I don't mean to rush anyone. I have an appointment outside the office at 4. I just called that person. They said they're running late, so it'll be about 4:15. So if you need another 10 minutes to confer some further, I've got a little more time than I thought.
I think we can proceed, Judge.
I'm sorry?
I think we can probably proceed now. I don't know that an additional 10 minutes is going to resolve anything further.
Okay, we'll just wait for Mr. Howard.
Yeah, let me see if I can contact my client and see where he's at real quick.
Okay.
My client says that he has a screen that says he's in the waiting room.
Yes, now. Thank you. And I'll admit him.
Thank you, Ms. Carr.
Yep.
Howard, can you hear the court?
Yes, I can, sir.
All right. Well, the court will call the case of Stephen Howard versus Rebecca Howard. This matter is before the court for a continued pretrial conference. The parties engaged in mediation with Mr. Pratt for the front of the court for the last couple of hours. Ms. Carver, the parties been able to make any progress? I know we put a partial agreement upon the record back in June, and they still had a few reminding the court thought were minor issues. Have the parties been able to work through those this afternoon?
No, we have not, Your Honor. We still have those remaining issues, and opposing parties have brought up some other issues related to things that we had put on the record back in June. So at this point in time, it doesn't look like we have an agreement.
Would it assist if you mediated with Mr. Pratt for another hour or half hour? Would that make any difference? I know I contacted Ms. Pratt to let her know that I had an appointment at 4 o'clock. So I didn't mean to rush the parties, but will an additional 30 minutes make any difference?
I don't believe so, Your Honor.
So what, do you have a trial?
I guess that's where we're at.
Your Honor, if I briefly may, just regarding what was placed, just a couple of the issues regarding what was placed on the record back at the end of June. This was prior to my involvement in the case, and I do have a copy of the transcript. It does appear that there was a custody, parenting time, and child support agreement placed on the record And then the only other thing placed on the record was the amount of equity in the home that my client would receive at closing. The custody and parenting time we agree with. The issue regarding child support is that upon a review of the guidelines, my client's incorrect income information was included. So there was an error in the calculation. Therefore, there's an error in the amount that was placed on the record. My client, her income, according to the friend of the court's recommendation, my client's income is $80,729.88. She is a respiratory therapist at Corewell Health. Her income is right under $68,000 annually. We have just the way that her pay structure is, she gets paid. It always comes out to
Ms. Patel, it's not the time we're going to argue about child support right now. Do you want to refer back to the front of the court for a revised recommendation?
Yes.
Any objection, Ms. Carr?
Well, we did have an agreed upon child support amount, and frankly, Ms. LaPrade did the calculation based on the income information that Ms. Howard had provided as of that date. I have looked at her pay structure, and I do not agree that she makes just $68,000 based on the pay structure that she's provided for. So, I mean, we're happy with the child support amount that was put on the record back in June.
Well, was that discussed during mediation this afternoon, Ms. Patel?
Yes.
Well, Ms. LaPrade should be able to make a recommendation. The court is inclined to follow her recommendation regarding that child support. And there's no sense in referring it back to the front of the court for another formal investigation if Ms. LaPrade has reviewed the pay stubs and the argument of both sides.
Well, we don't have all of at the time that it was referred, and just briefly, Your Honor, I'm not trying to argue child support. I'm just trying to explain my client's income. She is a respiratory therapist. The way that her pay works, she works every other holiday and every third weekend.
Okay, we'll deal with that at a trial. But you argued that with Ms. LaPrade, presented your argument this afternoon. Is that correct?
Yes, Judge. However,
all right, so we're not going to re-argue it this afternoon before this court. We can argue it at a trial. But if Ms. LaPrade make a recommendation, the court's inclined to follow that recommendation. But if you want to order re-argue it at a trial, then you could do so. But now is not the time. Okay. So do we want a trial date, Ms. Patel? The closing from the last the three issues were 3 cats in a joint bank account. I thought, boy, that should not be hard. Because I can tell you right now, we're going to put the 3 cats up for adoption and we'll split the bank account. It would just matter whether it's 50-50, 70-30, 60-40, however that's split. But the cats, I'm not going to argue over cats. They can be donated to the Humane Society.
The cats are.
But the parties can bid against each other. Who wants to pay the most for the cats?
I don't believe the cats are an issue, Judge.
Oh, okay. All right. That's what was informed on June 28th. Maybe you're not involved then, Ms. Patel. So what is that issue? The joint bank account and child support?
Joint bank account, child support, and spousal support are the big issues.
Okay. Any spousal support should be short-term rehabilitative spousal support due to income disparity.
I agree, Judge.
That's a relatively 14-year marriage.
It'll be 15 years at the end of this month.
Okay.
The end of next month.
All right. All right. So no further mediation would be meaningful. You want to evidentiary hearing then, Ms. Patel, Ms. Carr?
Yes.
Yes.
Okay, do you want to place any further agreements on the record this afternoon? Because the cats are no longer an issue. Is that correct?
I believe so, Ms. Carr.
Do you want to put that agreement on the record so we can at least reduce the issues as subject to trial?
Your Honor, I don't believe that we do have an agreement on the cats. I'm sorry at this point, because we were not able to resolve any issues as far as I'm concerned, because we were negotiating back and forth and there was discussions that were had regarding the cat, but I don't believe there was a final resolution. There's only one cat at issue.
Oh, one cat.
Father is requesting one cat, and there was discussion, but I do not believe that there was a final resolution to that matter.
Okay, so what happened to the other 2 cats?
They've agreed that mother can take the other 2 cats. They're not at issue. Right. It's one cat, Maisie, that was at issue.
Okay. Well, if mom gets 2 cats, Miss Howard, why isn't Mr. Howard get 1 cat then?
Rebecca, you're muted.
I am muted. I'm sorry. The reason why it's not decided because in today's
mediation, he stated, I was told that he stated that he would not go to trial. So he would not go to trial over a cat. So then I assumed at that point, if he's not going to go over the trial, then he's willing to give her up. I was informed that he's not willing to go to trial over that.
So, Your Honor, as the court knows, mediation is confidential. And as I stated, I don't believe there was a final resolution. There was discussions had.
Okay. So what did we, so we have an issue over, let's say all three cats it's on the table and the joint bank account. Is there anything else at issue, or has the joint bank account been resolved? Or is it everything at issue? Everything at issue other than what was put in the transcript back on?
So, yes,
June 28th?
everything, I would just say at this time, Your Honor, I think everything is at issue then.
Wow. Okay. All right. So can we do this in half a day, or do we need a full day evidentiary hearing? It'll be in person.
Probably need a full day.
Okay. Has all discovery been concluded?
No.
If we're going to trial, no. All discovery has
Okay.
not been concluded.
The court will not schedule an evidentiary hearing until discovery has been concluded. So how much time do you need to conclude discovery?
As far as 60 days?
Yes, 60 days.
Okay, let's see this. Grab the calendar. Yep. So you want another pretrial conference early December?
That works, Judge.
Friday, December 13th. Final pretrial.
That works for my schedule.
Ms. Carr?
That would be fine.
8:30 a.m.?
That's fine.
Okay. You want a teleconference, or do you want to do it by Zoom?
Either is acceptable to me.
Okay.
Thank you, Your Honor.
We'll do a teleconference so the clerk can have a frank conversation with counsel. December 13th, second Friday in December at 8:30 a.m. Court will initiate the call. Anything further this afternoon?
No, Judge, thank you.
No, thank you.
All right, the court would encourage counsel and the parties to continue to work toward the final resolution of these issues. The money that you're going to spend on litigation, Mr. Soward, will probably outweigh the value of things you're arguing about. Because, of course, we require trial briefs, preparation, discovery. The two of you need to be realistic. Resolve your own differences. And child support, if there's an issue about child support, I guess you can file a motion. I don't know, is there currently child support order in place right now?
No,
there is not, Your Honor, because the parties are still residing together.
Gotcha. Okay. Okay. So that can be addressed at later dates. Okay. Anything else?
No, Your Honor, thank you.
All right. That will conclude this pretrial. Thank you, Mr. Pratt. And everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you.